at least the ANC, and they would have made a difference, the 159, took a decision under rechtsdwalling and thus didn't properly apply their minds and didn't realize, in fact, everyone except the DA possibly don't appear to have realized that they did have a discretion and the freedom to vote as they chose, and it was a majority vote. But a majority vote based on the fact that you had a choice, which is what they were not aware of, as we've shown you. If you're with us on that ground, the appropriate order is to remit. So if you're with us on the error of law, the third ground, that they didn't realize that they could vote as they wished, and they thought they were bound by the convention. So even though they voted and the majority carried the day, the majority was misinformed as to the legal basis for what was up to vote for. If you uphold that ground, the appropriate order is to remit.
Isn't the error of law actually the beginning of if we with you on that point, on the error of law issue, if that's the end of the matter?
On the...
Then I'm missing something.
3 minutes. On the principle of constitutional avoidance, yes. If you're with us on that, you don't need to go to the other two. But we submit, given the importance of the matter, given the importance of the other two, if the court is with us, it would be appropriate to give guidance. I've got 3 minutes. So can I just finish? I'm not going to give you the context. The context is in our heads. But apropos of this issue, the European Court of Human Rights, in the advisory opinion at para 94, says the following. In considering the legality in terms of the European Convention on Human Rights, Protocol 3, as to whether a lifetime ban is valid, the court says in this connection, and turning to the criteria which are relevant in deciding that issue, in the court's opinion, they should be objective in nature and allow relevant circumstances connected not only with the events which led to the impeachment of the person concerned, but also and primarily with the functions sought to be exercised in the future by that person to be taken into account in a transparent way. This is because the purpose of the impeachment and the subsequent ban is not primarily to impose another sanction on the person concerned in addition to a criminal sanction, which may already have been imposed, but to protect parliamentary institutions. The relevant criteria should therefore be identified mainly from the perspective of the requirements of the proper functioning of the institution of which that person seeks to become a member, and indeed of the constitutional system and democracy as a whole in the state concerned. We submit that is pertinent. You are aware of the constitutional injunction that permits or requires this court to consider international law. And we submit that is precisely in line with our submissions. The purpose, one of the arguments by our learned friends is double jeopardy. We're seeking to punish Dr. Hlophe again, but they misunderstand the nature of removal from office in terms of 177. 177 is clearly not a sanction. The removal from judicial office is not a sanction. It could not be, because among the grounds to remove someone in terms of 177.1 is incapacity or gross incompetence. And yet the result in each case is the same. The National Assembly must call for a judge found to be subject to one of those three disqualifying conditions to be removed from office. The President must remove such a judge. So removal for a judge suffering from an incapacity, rendering him or her incapable of being a judge, clearly isn't and could never be construed as a sanction. The purpose of removal in terms of 177 is the same purpose identified in the advisory opinion. It is to protect the judiciary. It's not meant, although inevitably it has the consequence of affecting the individual concerned. That's not its purpose. Its constitutional purpose is to uphold the integrity of the judiciary. And that's what this court is enjoined to uphold as well. So for those reasons, we stand by our submissions. We move for the relief sought. We ask for the costs, which we do on a punitive scale, and that is because of the quite serious and unwarranted and quite frankly scandalous averments made by the parties, the respondents, and their failure to distance themselves from it when called. I'll sit down immediately. That's a good business.
May it please the court. What one needs to understand about this case is that attorneys get paid by the page and advocates by the hour. And that is why you have thousands of pages of paper and the C and I who will be sharing our slot. What we'll try to do is to demonstrate to you that this is a very simple case and that you shouldn't be confused by all the paper and all the arguments. We advance 4 grounds of review. I will address the first 2, and that is firstly that the JSC failed to exercise the discretion conferred on them. Secondly, the National Assembly. National Assembly. The second is that the National Assembly failed to discharge the duty imposed on them under Section 165(4) of the Constitution. Those are the 2 that I will address. My learned friend will address 2 further grounds of review. Firstly, that the decision of the National Assembly was irrational and unreasonable. And secondly, that they took into account relevant and irrelevant and ignored relevant considerations. And then I'll say a few words about remedy. There are really just 2 aspects to it. The one is severability, because we do submit that we need, it's proper to declare invalid the nomination of the designation of Dr. Hlophe, because that's the issue before you. The question whether that can competently be done, despite the fact that we was one of 6 people nominated by the same decision, that's a severability issue, and we will address that issue. My learned friend will lastly say something about punitive costs. May I then deal with the first ground of review? It's addressed in our heads of argument. It was addressed in the full bench judgment in paragraphs 58, 59, and 64. And this is simply that the National Assembly failed to exercise a discretion vested in them. And in fact, not that they failed to do so because they didn't realize that they had a discretion. And this is the discretion in the exercise of their designation power under Section 178(1)(h). That is the discretion or the duty articulated in Helen Suzman paragraph 37, to which reference has been made. But if you will forgive me, if I may just read it again to emphasize our point. The Constitutional Court said in Helen Suzman paragraph 37, that's in case lines.
Is someone inviting us as a jury? Is Mr. Bishop still with us?
He is, yeah. But I think this case has already been on case lines for some time. But if I can just give you the reference. The paragraph appears at 45-149E, where the Constitutional Court said the following. Since courts play a crucial role in our constitutional democracy, without doubt the JSC's function of recommending appointments to the senior judiciary is of singular importance. Bearing in mind the importance of this function, I do not think it unreasonable to expect that those that bear the responsibility of nominating, designating, or electing individuals for membership of the JSC will take their responsibility seriously and identify people who are suitably qualified for the position. In other words, they have a very wide discretion, but they have a duty under the Constitution to exercise that discretion in the discharge of this duty, and that is, to do so responsibly and seriously, to identify people who are suitably qualified for the position. That was the discretion and the duty conferred on them. And the fact of the matter is, they didn't exercise that discretion. We don't even need to debate whether the discretion was correctly exercised or not, because the flaw is more fundamental. They didn't exercise it at all. And Justice Basson, our heads also characterized that flaw as a mistake of law. And that is so. They committed a mistake of law in the sense that they didn't realize that they had to exercise their discretion under this duty. But the first fundamental flaw is that they didn't exercise that discretion, whatever the explanation for their failure to do so. We know that the explanation for the failure is that they made a mistake of law. But one doesn't even need to go there. The fact is, it's common cause. They didn't exercise that discretion, and that is fatal to their decision. But if you will forgive me to cite one or two cases which are not in our heads, but on this point. The category of reviewable irregularity that we're speaking about was described by the Constitutional Court in the Saru case, that's President of the Republic of South Africa versus South African Rugby Football Union, 2000, Volume 1, SA, Constitutional Court, in paragraphs 39 and 40, and particularly in 40, where the court discussed the category of reviewable error of what is called abdication. That's where a party vested with a discretionary power abdicates that power by failing to exercise their discretion. And the court endorsed Baxter's classification of that various categories of abdication. In paragraph 40, the court speaks of two categories of abdication, the second of which reads as follows.
I'm trying to follow you. It's not here the page reference. It's 2000 volume 1 page.
Page 1 at page 28.
Volume 1? Is it volume 1?
Yes. 2000
Yes.
volume 1,
Yes.
page 1
Thank you.
at page 28. Paragraphs 39 and 40. And the court said the following in paragraph 40. The second category referred to by Baxter deals with cases where a functionary vested with a power does not of his or her own accord decide to exercise the power, but does so on the instructions of another. The third category of passing the buck contemplates a situation in which the functionary may refer the decision to someone else. Now, what happened in this case is that by far the overwhelming majority of the members of the National Assembly wrongly assumed that they simply had to endorse the nominations made by the opposition party, and in that way abdicated their responsibility, their discretionary power to perform the function imposed on them under Helen Suzman, paragraph 37. The same category of reviewable error was described by the Supreme Court of Appeal in the Cinematic case, that is Minister of Environmental Affairs and Tourism, the Cinematic, S-C-E-N-E-M-A-T-I-C, Cinematic 14, 2009, Volume 6, SA, page 182, SCA, paragraph 20. I'm not going to read it, but the court there summarized and referred to and summarized the principle that where a discretion is conferred on a functionary, then the functionary, him or herself, must exercise that discretion and cannot defer to anybody else.
Just repeat the citation for my benefit.
It's Minister of Environmental Affairs and Tourism, Cinematic 14. The reference is 2005, Volume 6, SA, page 182, SCA. The particular paragraph occurs at page 199, and it's paragraph 20. Now, I'm not going to traverse all of the evidence on what happened in the National Assembly, but what I'd like to do is just to touch upon the core pieces of evidence that makes it clear that what happened in the National Assembly was that the overwhelming majority of the parties thought that they were bound by the convention applied to the designation of parliamentary committees, but namely that the nominations of the parties be accepted without question. In other words, the majority opinion in the National Assembly was that they were bound merely to endorse the nominations of the minority parties, and thereby they abdicated their discretionary power, which they failed to exercise. There is firstly the letter of the Speaker to which you've been referred. I won't take you there, but it's the letter of the 9th of July 2024. It is in case lines at 02-230. And you'll see that the Speaker said that paragraph 1, I've taken note of the contents of the correspondence. As you'll be aware, section 178(1)(h) of the Constitution requires that the composition of the JSC must include 6 persons designated by the National Assembly from amongst its members, at least 3 of whom must be members of the opposition parties. And here comes her error. She says, the Constitution therefore only includes 2 requirements in relation to the designation of persons by the Assembly. Firstly, that the person be a member of the Assembly, and secondly, that half of the persons so designated be drawn from the opposition benches. There are no further criteria. Well, it might be an understandable position, but it was a mistake. She had not read Helen Suzman, paragraph 37, and did not appreciate that there is a duty on the National Assembly, when it exercises that power, to exercise it as Helen Suzman, paragraph 37, had dictated. It is clear also from the debate that that was the prevailing view. And instead of referring you to the transcript itself, there is a convenient summary of the debate in the Speaker's answering affidavit from page 05-14. And I invite you to read it because it's a fair summary of what was said, but I merely emphasize 1 or 2 extracts from the debate. For instance, we'll later look at the position of MK, but at page 05-24, Mr. Shivambu, then a member of the EFF, said, addressed the issue and concluded as follows, and that is at 05-25. So let us respect the fact that a certain number of people in South Africa voted for the MK party and have designated Dr. Hlophe to become a member of Parliament. So let us respect that. It is a matter of protocol which we have always protected in the Chief Whip's forum, for that whatever is designated by a political party must be respected. So we will wish well Dr. Hlophe in the JSC. He echoes that understanding that the convention is that they rubber stamp the nominations of the political parties. And then the Chief Whip of the ANC spoke last and summarized the debate, and that appears at page 05-29, paragraph 53, where he summarized the debate. I'm not going to read it. It was referred to by the full bench in their judgment, but the reference is 05-29, paragraph 53, where he also articulates this understanding that the CA was bound to rubber stamp the minority party nominations. As for the party before the court, MK, Mr. Zuma in his answer articulated precisely the same understanding, and I refer in this regard to his affidavit 06-25, paragraphs 60, 61, 66, 141 and 142. And he says, for instance, in 141, I admit that no political party represented in the National Assembly, including the DA, contradicted or challenged the established autonomy or prerogative rule or convention which provides that the decision of nominating opposition party is binding on the National Assembly, nor does any party seek to review that convention. As for the MK's heads of argument in this hearing, this court, at 047-8, paragraph 17.4, says MK and one or two smaller parties were of the view that the National Assembly was bound to accept the nomination of Dr. Hlophe without any further ado, simply because that was the practice in the past. So they admit that that was the perception at the time. And then they say in paragraph 18, in retrospect and for the sake of progress, MK now accepts that the proposed approach may have been too rigid and therefore the procedure actually followed by the Speaker was the correct one. Well, no. The procedure she proposed was merely that a decision be taken, but that the decision would only be governed by two questions, so that on his own, on their own rendition, they were mistaken then, but with respect, they are still mistaken. Dr. Hlophe's heads of argument here articulate the same understanding. And if I may just give you the reference, it's at 45-12, paragraphs 5.11 and 16.2. And if I may just read 16.2 to illustrate the prevailing misconception. It says, Section 187(1)(h) of the Constitution gives opposition political parties represented in the National Assembly the right to be represented in the JSC. That is not so. Those representatives are representatives of the National Assembly. It is true that they must be drawn from the minority parties, but the decision to nominate, to designate them, is a decision of the National Assembly. And when it does so, they represent the National Assembly. It goes on to say, in other words, Section 178(1)(h) restricts the power of the majority to dictate to the opposition parties who in the opposition parties should represent them. It's again the same mistake. The majority decision is taken. It must be taken in accordance with Helen Suzman paragraph 37. what the Constitution requires them to do is to pick 6 of their nominees from the ranks of minority parties. But it remains a National Assembly decision in the appointment of representatives of the National Assembly. They go to Parliament as National Assembly representatives, not as party political representatives.
Parliament go to the JSC.
They go to the JSC, you're right. So, our first point is that they were under the duty to exercise the discretion described in Helen Suzman paragraph 37. They didn't realize that they had such a duty, and for that reason didn't exercise that discretion. So it was what the Constitutional Court called an abdication of their responsibility. But you could also characterize it as a mistake of law, because the reason they didn't exercise that discretion was that they didn't understand that they had one. So that you can actually characterize the same flaw in 2 different ways, both of them fatal to their case. There's a second ground of review, and that is the failure by the National Assembly to discharge its duty under section 165(4) of the Constitution. The full bench addressed this flaw in its main judgment in paragraphs 60 and 61. And this, frankly, is an almost identical flaw to the first one, because what it is that there was not only a Helen Suzman paragraph 37 duty on the Assembly, there was also a constitutional duty on the National Assembly under section 165(4). And may I just remind you of its text. Organs of state, i.e., including the National Assembly, through legislative and other measures, must assist and protect the courts to ensure the independence, impartiality, dignity, accessibility, and effectiveness of the courts. So there was a clear duty on them. They have a very wide discretion to determine for themselves how to pursue that objective. But they must at least, when they take that decision for the appointment of people to the JSC, they must at least be aware of this constitutional duty and, to the best of their ability, pursue its command. Its command is that they must assist and protect the courts to ensure the independence, impartiality, and dignity. There might be many ways in which that can be done. But again, the flaw here is more fundamental. What we're debating for purposes of these 2 grounds of review is not the outcome. It is the failure in the decision-making process, because they abdicated their responsibility by blindly rubber-stamping the nominations of the minority parties. So we submit with respect that those 2 grounds of review are fatal. My learned friend will address 2 more grounds of review. Let me just say something in conclusion about remedy. If you find that the nomination of Dr. Hlophe was unlawful, then you are required under section 172(1) of the Constitution to declare it to be unlawful. And if I may just give you 2 citations of the emphasis of that duty by the Constitutional Court. The one is Economic Freedom Fighters, the Speaker of the National Assembly, 2016, Volume 3 SA, 580, Constitutional Court, paragraph 103. And then also all pay. Sorry, can I repeat that reference? 580, paragraph 103. And then the other one is all pay, v. SASA, South African Social Security Agency, 2014, Volume 1 SA, 604 CC, paragraph 25. There's one remaining question, and that is that our learned friends say, how can you declare only Dr. Hlophe's nomination unlawful and invalid, whereas he was one of 6 candidates who were appointed by the same decision? Well, the answer, there are 2 components to the answer. The first is that is the only appointment challenged before you, so that you don't have jurisdiction and you don't have any competence to consider the other appointments. The only question that you need to ask yourself is whether it is competent to declare one nomination invalid and not the others. Now, remember, there's nothing peculiar about it. Our laws, our courts hear challenges to legislation every day. All of those laws are laws adopted by one parliamentary decision. So it's not uncommon to have a challenge to a part of a law or an administered decision with many other parts. And the only question you need to ask yourself is whether the unlawful part is severable from the rest. And the severability test was authoritatively articulated by the Constitutional Court in Coetzee's case. That is Coetzee
With a K or a C?
with a C. Coetzee v. Government of the RSA, 1995, Volume 4, SA, 631, Constitutional Court, paragraph 16. And it's a simple test. You ask yourself whether the good can be severed from the bad. And to answer that question, you ask whether the good and the bad are interdependent, whether the one is dependent on the other. Well, there is absolutely no reason in this case why you shouldn't sever the one appointment from the others. They're not dependent on one another at all. Nobody can suggest that the decisions are dependent, or the appointments are dependent on one another. And then, Justice Basson, to your question, we would submit that the appropriate order would be firstly to declare Dr. Hlophe's appointment unlawful and invalid, and then, of course, refer the issue back to the National Assembly. But what is referred back to the National Assembly is the vacancy that arises when you declare his appointment invalid. What then has to happen is that vacancy has to be filled afresh. And we're not asking you to prescribe to the National Assembly whom to appoint in his stead. Of course, others do. And if they were to appoint Dr. Hlophe again, there might be another round of litigation. But that is not the case that we...
The joint practice, Mr. Trimble, isn't that what you suggested? Did I miss something? I read the joint practice note in terms of the degree waiver that I thought you changed stats. I read it wrong.
Let me just say, my two rounds of review merely says that the decision was invalid. And if you find on the basis of any of those two grounds, then the effect of it is that the appointment was unlawful and invalid, and you set it aside, and what gets referred back to the National Assembly is the decision to fill that vacancy. There are others who say that Dr. Hlophe can never be competently appointed, and therefore that it would be unlawful for the National Assembly to appoint him again. But that's a further step, not one that, in my part of the argument, is being applied. Thank you, Mdntv.
Thank you, James. Thank you.
Justices, Mr. Trengrove, our learned leader, has shown you that despite all the attorney pages and advocate hours, the case remains simple. And that's because he has dealt with the first two review grounds on behalf of Full, and has explained to you that there was what he called, and I'll follow that example, a paragraph 37 HSF duty that the National Assembly didn't recognise, and a separate section 165(4) duty that they didn't recognise, and that therefore the discretion that was upon them wasn't in fact discharged. My duty is to deal with the next two review grounds, and that is to show that in addition to the National Assembly abdicating its discretion in that way, it also abdicated or failed to consider that there were two further constitutional duties on it as a body when it exercised the powers that Section 178 of the Constitution permitted. And that means two additional constitutional considerations. The first being that all power must be exercised rationally. And secondly, that when you exercise power, you must properly consider materially relevant considerations in order to meet the purpose of that decision. And I'm also going to say something about punitive costs. So let me get into those two review grounds. Before I do so, with respect, we say that there are governing and clarifying principles of judicial review which keep the case particularly simple. There really are three, and the principles have come from the leading courts in the country. They are not just guiding, but they are also binding principles. The first principle is this. I'm going to call it for shorthand the Similani principle. It comes from a case involving the unlawful appointment by President Zuma of Mr. Similani as the National Director of Public Prosecutions. The citation of the case is the Democratic Alliance versus the President of the RSA. It's 2013, Volume 1, SA 248, Constitutional Court. And it's dealt with in Fool's Heads in detail at paragraph 106.4 at case lines 45-39. And Justin Dow, I don't know whether the invitation has yet been extended to you.
Nothing, I'm waiting patiently.
But all of the references I'll give you, Justices, are to the case lines references, so you'll be able to look them up in your own time. The principle is a straightforward one. It says this from the Constitutional Court. For a decision maker, like the National Assembly, to act rationally, it must consider properly all relevant considerations. Why? Precisely to ensure that the purpose of the Judicial Service Commission in this case can be met. And relatedly, says the Constitutional Court in Similani, I'll come back to this in a moment, if you're going to overlook a consideration, you have to explain why you overlooked it. And the principle works like this in this case. The decision-making process that was adopted can render that decision irrational if, in that process, the National Assembly ignores information that was materially relevant to the fulfillment of the legitimate government purpose in issue. So the first and obviously relevant issue here is that Judge Hlophe was stripped of his judicial robes for not just misconduct, but a particularly egregious form of misconduct, so serious as described by our courts, as to destroy confidence in the judge's ability properly to perform the judicial function. And what that means is that the National Assembly was going to have to do some very careful and credible explaining for ignoring that relevant consideration of Dr. Hlophe's impeachment and the impact on the public's confidence in the judicial process. That there's no proper explanation whatsoever for ignoring that consideration. And so we say again as a starting principle, the Constitutional Court's decision in Similani makes this court's task easy because it confirms that unlawfulness. The Constitutional Court said it clearly in Similani through this lens of rationality. It said, if there's a failure properly to take into account or explain the failure to take into account a material consideration, then, and these are its words, it colors the whole process as irrational. So that's Similani's importance for this court. Similani is important for another reason. We've heard reference to separation of powers and we expect our learned friends will try to argue that the decision by the National Assembly should be respected by this court, or shown some form of deference. But with respect, deference doesn't enter the picture to shield or cloak decision-making by the National Assembly from the rationality standard and the scrutiny of that standard by this court. Because the Constitutional Court has said as much again in Simelane. In Simelane, justices, it faced the same argument. The arguments on behalf of President Zuma in that case was, but this is my decision. It's a politically sensitive decision. I'm choosing the National Director of Public Prosecutions. That involves policy considerations and politics. And it's for me to make that decision and not for you as the courts to interfere. And the court said the following in saying that that argument was entirely misconceived. And I'll give you the reference. It's in Freedom Under Law's Bundle of Authorities at case lines 45-651. And this is what Justice Yaqub said. He said, the separation of powers has nothing to do with whether a decision is rational. In these circumstances, says Justice Yaqub, the principle of separation of powers is not of particular import in this case. Why? Because either the decision is rational or it is not. And so the Constitutional Court justices has made clear that separation of powers and deference play no role to cloak or to shield this court's scrutiny of executive power. The rationality standard itself recognizes that this court can do so. But I would stress that when you reread it, you will notice that the Constitutional Court speaks about the responsibility, in other words, the duty on the persons who are going to be making this decision. They must discharge that duty seriously and they must identify people who are suitably qualified for the position. And not just the ether, but bearing in mind in that passage the importance of the function, which is the critical place of judges in our democracy. And here, Justice Bill.
Dr. Hlophe says that from the time there are allegations and throughout the process of him between that time and the time of his suspension.
Of the LNCG judgment, won't that be sufficient for purposes of this exercise?
No, because that's with respect, that's only part of why their conduct was unlawful. The conduct was unlawful because they didn't do what the law required. They didn't follow paragraph 37. But their conduct was also unlawful because it was irrational. It was irrational and unreasonable to appoint to this fundamentally important position a person such as Dr. Hlophe, given the findings. And so we are saying that a declaratory order is necessary and is unrepentant about it. It would be different if he said, oh, I now see I made a mistake. He would never do it again. But he's unrepentant about it. He says he was entitled to that decision. And we say a declaratory order is necessary to avoid a repetition of the very conduct which lies at the heart of the function, which led to the impeachment of Dr. Hlophe. We don't say that this is a case of a prohibition in perpetuity. Circumstances may change. For example, if Dr. Hlophe publicly said that he accepts that what he did is wrong and he would not do it again, he'd be entitled to come back to court and say, well, now I'm a suitable person to be designated because I'm no longer the person that I was when I committed this misconduct. But he so we accept that circumstances may change, and therefore it would be permissible for if the court grants that declaratory order, it would be permissible for Dr. Hlophe to come back in due course and say, facts have not changed, please reconsider.
But now what happens with an order against the National Assembly that is
Yes.
in perpetuity?
Well, the simplest way to deal with it would be to make a more limited declaration. And if I can just find my note on this. Yes, the court could simply make a declaration that Dr. Hlophe is not a suitable person to be designated a member of the National Assembly. That's all. No declaration that he will never be a member. The declaration that he is not a suitable person to be designated a member of the National Assembly. That's not a finding of perpetuity because circumstances may change. You can come back and say, I wasn't suitable, but I am now suitable. So that's not a finding of perpetuity. And the court would make it clear in this judgment that this is not